Welcome to the Student Faculty Seminar of the Presidential Lecture Series and the Philosophy Forum. It's a special pleasure this afternoon to welcome Anthony Romero. He is the Executive Director of the American Civil Liberties Union, and he assumed the directorship exactly a week before 9/11/2001, and rose to the challenge of defending our civil liberties against the onslaught that came from a sometimes irrational and misguided fear of terrorism. And he left his mark in rallying the troops and doing the right thing at a moment when our civil liberties were nationally in jeopardy. A second accomplishment, less conspicuous but just as important, is due to his realization that civil liberties need to be defended not only on these great occasions when everyone's eyes are on the center of power, but every day and everywhere in the particular circumstances across this country. And so he has greatly strengthened the state ACLU organizations and raised the money needed to support them and sent the money their way. And we here in Montana have been beneficiaries of this far-sighted and important initiative. You'll get a full account of Anthony's background and accomplishments this evening at 8 o'clock in the Denison Theater, when Larry Abramson will introduce him, and Anthony will talk about civil liberties in America today. And he will now engage you in a conversation about civil liberties. Please help me welcome Anthony Romero.
Microphone should be on. So Professor Borgman, thank you very much for that kind introduction. Thank you especially for your daughter, who works with us as the head of our affiliate here in Montana. And I've known her now for almost 14 years. When I first arrived at the ACLU, she was a staff attorney at her national office. And so it's been a thrill to watch her both stay with us out of New York and then move here to Montana, back home to her roots. And where is Caitlin? I'm trying to find her. I see my touch. Yeah. And she has done a tremendous job. And sitting next to her is the man who first brought me to Montana many, many years ago, Scott Crichton, who is a long-standing director of the ACLU of Montana, who stepped down the road a year ago and helped build this great office that Caitlin now is privileged to lead. And so a tribute to both of our colleagues who are here. We've done great work, and we're so lucky to have you here. So I have a proper lecture to give tonight. That's what I'm told. It's the President's lecture, so it will have all the bells and whistles attached to a presidential lecture. It's properly formatted on my stationery. It's got some punchlines. It's got some stories. But I thought I would do is have a much more informal and interactive moment with all of you today. And so I don't plan to speak for terribly long now, and then hopefully open it up for more of a give and take. It might be a little harder to do tonight, so I thought I'd use the opportunity to begin in a rapport. I learn a lot when I hear what different people are thinking about and how they're seeing the world and what questions they put to me, so it helps also me think about the work I do and what we need to do better or differently. So, to be very short, the ACLU is 96 years old this year. We were founded at the very beginning of the 20th century, at a moment of enormous change and unrest in early American 20th century history. And in that time, our mission has remained very much the same. It's evolved enormously as the times have evolved, but our goal and our mission was to defend the rights of everyone in the U.S. Very kind of lofty mission. And it came out of a time when we saw the deportation of thousands of European immigrants who were considered to be the enemy within during the Palmer raids, the rise of the labor movement, which was very tumultuous, at times violent. You had the rise of even an anarchist movement at different moments. You had countries as objectors who had begun to get organized after the First World War. And so you had a moment of enormous unrest and change. And out of that, a band of very idealistic, very young, for the students in the room, they were in their 20s, said that we needed to establish an organization that would defend the rights of all people. And that's what led to the creation of the National Civil Liberties Bureau, that 2 years later we renamed the American Civil Liberties Union in 1920. And it was kind of crazy when you think about what they thought as their mission. This was a time in 1920, if you rewind and you go to your history professors, it was a time when there had not even been one Supreme Court case yet that had upheld the right of freedom of speech of an individual against onerous government censorship. That would come almost 9 years later. Blacks were second-class citizens by rule of law. Women didn't have the right to vote. There was no history of using law or litigation or advocacy to champion people's rights. There were injustices that were evident to people at the time, obviously going back to the time of slavery and then obviously with emancipation. But there was no history of trying to redress those injustices by taking private civic action. And so when they founded an organization that said, we're going to stand up for the rights of everyone, someone's going to stand up for us, that was really quite remarkable and I think quite visionary. That's why the founder, Roger Baldwin, Crystal Eastman, Jane Addams, Margaret Sanger, even Helen Keller, one of our founders, are folks who are known for their other accomplishments, but I think this one is as great, if not as important as the others that they later on went on to achieve. Our mission remains that we believe that no matter who you are, you have certain rights that can't be taken away from you, these inalienable rights. And over the years, we've played a leading role, often underappreciated or not fully understood, in kind of iconic moments in American history. If you go to some of the earliest cases that we've had, we represented a group of young African-American men who were being prosecuted for the alleged rape of a white woman in the South. It was the Scottsboro Boys case, a very famous Southern case, which was one of those instances of racial profiling, racial animus in law enforcement, kind of almost reminiscent of some of the same issues we contend with today with Black Lives Matter. Our biggest blockbuster case is one you all know, you probably don't know it's ours, is the Scopes trial, the Inherit the Wind, the monkey trial. We found Scopes. The founder of the organization posted an ad in a local Tennessee newspaper saying, if you're a teacher and want to teach evolution in science classrooms, please be in touch. We heard from Scopes. We found Darrow. We connected Darrow to Scopes, fought the prosecution of Scopes, lost. Most people forget the fact that that was the case and we ended up losing. But it was one of these iconic moments that helped emblaze and kind of in media and TV and movies and public attention of the need for a lawyer to stand up for an individual's right to teach science in a science classroom. Where would America be if we had not taken that step? You fast forward over the years, Korematsu, the opposition to Japanese-American internship during World War II. Our organization was one of only 2 national groups who had the courage to stand up to otherwise great free-thinking liberals. FDR as president signed the internment order. Hugo Black, when the Supreme Court penned the opinion. Earl Warren, also in California, the Attorney General at the time. Moments when we had to stand up to what were otherwise supportive and progressive-minded leaders. But we were tested then as we were tested after 9/11. The cases continued. I had nothing to do with them. I wasn't even born for most of them yet. But cases like Loving versus Virginia, the right for interracial couples to marry. Gideon v. Wainwright, the right to a court-appointed attorney if you can't afford one. Miranda, the right to remain silent. Griswold, the right to contraception. All of these were cases that were brought by ACLU lawyers over the years that helped define how we thought about rights and liberty in America in the 20th century. So with that history, with the legacy, where are we now? What are the issues that we think are most pressing for us? And so I just want to outline for you that what I think are the top issues we're paying attention to. I invite you to kind of comment, to add, subtract, agree, disagree, and then maybe say a little bit about the context of the Supreme Court at the moment, since a great deal is in flux there at this moment. So the issues that we think will define how we live and make good on the promises of those founding documents, that those were great aspirations that the founding fathers put in the Constitution, the Bill of Rights, even the Declaration of Independence, but you have to give life to them. And so they come to life in real, hard-fought battles. The ones we see most pressing are, I would start with criminal justice, and that will be the primary subject of my lecture tonight, so I won't spend as much time on it to keep it a little bit more fresh for those of you who have either the stamina or the insomnia to come to get a second thought. But for me, that is probably the most pressing civil rights, civil liberties issue. You've all heard the numbers. We are the world's largest jailer. We have 2.3 million people behind bars. 5% of the world's prison population, 25% of the world's, 5% of the world's population, 25% of the entire world's prison population. The highest per capita rate of people jailed than any other country, including China. And this is not some fact that just happened by happenstance. This was really, this legacy of over-incarceration was built up on decades of government policies that were explicitly designed to lock people up and to give, and to not give the discretion to judges or to community leaders. Politicians preyed on people's fears in much the same way you saw the way politicians prey after terrorist attacks. Politicians preyed on people's fears around crime. And so it began with Richard Nixon and the Southern strategy that was very clearly dog whistle politics, where Nixon tried to steal away moderate white voters in the South by painting images or perceptions of the African American community as hostile, as violent, as a community to be afraid of. Led into also the war on crime that was launched very much with Nixon into Reagan. The war on drugs was a complete and utter disaster, where we took what should be seen in our country as public health problems with addiction on drugs or alcohol, and then we raised the criminal stakes for individuals who had health challenges. And so we began to stockpile people in our prisons and jails, and then turned up the heat on them, where we enacted 3 strikes, you're outlaws, where 3 misdemeanors would then kind of entitle you to a much lengthier sentence, where we put in place policies like solitary confinement for individuals who were mentally troubled in institutions, where we would enact the use of life imprisonment without parole, even for nonviolent crimes. One of the things I would commend to you on our website is a report we did about 2 years ago. It's called Living Death, and it looks at life without parole for nonviolent crimes. And the analysis is quite good in the beginning. The first 20 pages, I think, are quite compelling. More compelling are the 100 or so pages that follow that show the personal narratives and the stories of people who've been incarcerated for life for nonviolent crimes. And you kind of read through those stories and you just shake your head and say, how can this be? How can this be? And so for us, criminal justice is a top priority, not only because the impact it has on all of our communities and stripping people who could be otherwise rehabilitated or engaged in the social fabric. It also because it's a unique moment that there seems to be a thawing in the political rhetoric, that you have Republicans and Democrats for the first time at least talking about the need for criminal justice reform. We've been working at the ACLU, we've been working closely with our normal allies, as you would expect, but then some rather new bedfellows, if you will. So we've been working closely with the Koch brothers on mass incarceration. We've been working with Ed Meese, who we fought mightily when he was in the US government, but now agrees with us that we have a wrong-headed approach over incarceration. We've been working with local Republican and Libertarian parties, including the Tea Party, including Right on Crime, to try to erode some of the policies and laws that have gotten us to this point. It's going to take us a very long time. It took us 30, 40 years to build this epidemic on incarceration. It's not going to happen overnight. And perhaps most vexingly is the fact that whatever we do, we have to do state by state. That there is no federal fix for this. You can't wave a magic wand in the Supreme Court or pass a magic bill in Congress and fix this all. You really are going to have to go state by state, reform by reform. And for us, the levers we're trying to pull, just to be quick, and then I'll move on to the other issues, are looking at sentencing reform, where we've had very draconian criminal sentences attached to certain crimes, looking especially at those crimes that don't pose major threats to our society. You start with the easy ones and you work to the hard ones. So looking, for instance, at nonviolent property crimes, shoplifting, nonviolent drug crimes like possession, looking at even the number of people who are incarcerated because they're incapable of paying their court-ordered fees, what we call debtors' prisons. All those should be easy to clear away the brush. Start with the easy stuff that's closest to us, and then build toward how you deal with more violent crimes and deal with individuals who are truly troubled, and what type of programs need to be put in place either to divert them to drug and alcohol treatment programs or mental health institutions. All of that, I think we're going to have to tackle over time. But I see a political willingness in a way that we haven't seen before. So sentencing reform. Indigent defense, which is the right to a court-appointed attorney if you can't afford one. And often we find that people will plead to a crime if they have more advice from a lawyer, if they're languishing in jail before they even see their lawyer. And that's often the beginning of the unraveling of a person's life. And so having a lawyer there who's equipped, who's trained, who's able, who's got resources to be able to assist that person who's charged with a crime seems to us critical. That was the promise of Gideon versus Wainwright, our Supreme Court case. It's one that's still not fully realized in all parts of America. There are people who literally will spend weeks in jail waiting for their court-appointed attorney to show up before they can be brought before a judge to enter a plea or to begin the proceedings. And so we think that's an essential part of it. We're looking at bail bond reform. The idea that the right to bail is an essential part of the American system, and yet it's one that very much disadvantages low-income and poor communities. And so often bail has been contorted now almost as if it were kind of a punitive measure depending on the crime that you've committed, rather than some type of assurance that the person won't flee the jurisdiction in the interim of the case. There are many people, and much of the research has shown that when charged with crimes, if they have ties to their communities, they have families, kids, jobs, homes, they turn back in court for their follow court date. And that the overuse and the misuse of bail has just kept people locked up and with an impact that's catastrophic in the future. So all of those are the levers we're beginning to pull on criminal justice reform, and I'm glad to talk to you a little bit more about it tonight. I hope to paint a more human face behind the statistics and the policies and talk about real people try to make it come alive a little bit, if you will. The second big issue for us is on LGBT equality. Here we all know that the major Supreme Court decision that was rendered last June was a watershed moment for LGBT rights in America. It was our case. Obergefell was our client. 2 years before, Edie Windsor was our client in the case that struck down the Defense of Marriage Act. Our very first same-sex marriage case was in 1971, long before anyone thought to bring a gay rights docket, or even before groups like Lambda, or Human Rights Campaign Fund, were even established. There was 2 guys who lived in Minnesota who wandered into the local Minnesota office and said, "God damn it, we want to get married." And then the fellow scratched his head and said, "Sure, why not? We'll try." And we filed that first same-sex marriage case in 1971. Didn't win, obviously, but it's really quite rewarding that some 45 years later we were able to bring that ball across the goal line. And it's fantastic. It's just the beginning, because unfortunately the way that it currently stands, in most states you can get married on Sunday now and fired on Monday for marrying a same-sex partner. And so there aren't sufficient protections against LGBT individuals from discrimination in the housing, employment, the public accommodations context. That is the next battle, to bring full equality to LGBT individuals. Marriage equality was a necessary first step, but it's only a first step. There are some increased opposition to this momentum. We will ultimately succeed on this one. This one I also feel very confident and very optimistic. It just matter how long, how difficult, how bloody the battle before we win. You've seen already in the press reports there have been efforts that, you know, the homophobes have now dressed up themselves in religious freedom, where they now discover that they're more concerned about their right to religious expression. And it's no longer appropriate to say in polite company that homosexuals don't deserve their rights. So now they have to dress it up with a concern for their own religious belief. I say that with the sarcasm on purpose, not to denigrate the need for religious liberty. It's an essential part of how we live in America. It's part of the First Amendment. It's kind of foundational for us. But it's also true that our country is probably among the most free in terms of religious expression of any modern Western democracy. And so I would be challenged to come up with many contexts in which an individual's right to worship a God or no God at all, or to go to a place of worship, is fundamentally impeded by government policies. Our population is among the most religious per capita of any of the modern Western democracies, and our people find a way to exercise their freedom of religion extraordinarily well. And where there are challenges, we fight them. You know, there are moments in which we have jumped in to help a large evangelical church get proper zoning authorization for opening up a church in a jurisdiction that is hostile to them. It's important that churches be allowed to be formed and where people are allowed to congregate. What is not appropriate is when some of our very same opponents who for 20 years fought us because they thought the gays were not worthy of their rights now turn out to be concerned for religious liberty and say, if you force me to acknowledge your marriage, either by allowing you to have your reception at my establishment or work at your wedding or officiate at your wedding, you're violating my religious liberty. If we allowed that level of individual choice to say, you have your rights, but don't make me acknowledge your rights if it offends my religious belief, we'll be nowhere as a country. It wouldn't be appropriate given how pluralistic America is and with all the different religions that are in place. I might have very strong opinions about other religions that I find are not in my worldview, but I have to treat everyone with the common decency and respect and non-discrimination as I walk and work in my life. I give the anecdote, the whole, why, Anthony, are you forcing all these small businesses to recognize LGBT marriages? Don't you find that problematic? And I often use the anecdote of my grandmother. My grandmother, if she were alive, would probably not be very happy with me occupying the same bedroom with my boyfriend. My grandmother was a very old-styled Roman Catholic woman. I'm not sure she loved me tremendously, but she'd be troubled with the fact that you're not married and I'm not letting you guys occupy the same bed. You take one bed, you take the sofa. Now, Grandma were to take that very same house and convert it into a bed and breakfast, where she enters the public sphere and has to put an exit sign in front of her front door, and has to have a smoke detector in every room, has to pay a room tax because that is what the local jurisdictions require for the hotel industry, or has to subject her kitchen to periodic inspections from the safety board. Grandma has now gone from the private to the public. She's a business. And whereas Grandma before didn't have to let me stay there with my boyfriend, if Grandma were running a bed and breakfast and we're renting out her room, she'd have to rent me out that room, because that's the price you pay when you enter the public sphere. And that's precisely the type of line drawing that we're trying to make clear in some of these kind of religious refusals laws, which are just kind of a thin veneer of 21st century homophobia that need to be shot down. You've been seeing them play out in places like North Carolina, Mississippi, and we have the headwinds to contend with there. Third issue that we're, I think, also succeeding is on the kind of privacy rights on the web. The right to be free from fear of government intrusion. If you've done nothing wrong, you should not be the subject of government surveillance. Which is obviously in the aftermath of 9/11 became a very big issue with the greater amassing of surveillance powers given to the federal government. Very much has changed. The game changer there was Edward Snowden and his revelations. He's our client. I've met him a couple of times down in Moscow, where the revelation showed us that our government was lying to us about the extent of the surveillance, the inadequacy of the checks and balances on the surveillance that was being conducted, and the need for ensuring that there's greater and more vigorous defense of people's personal right to privacy through our electronic devices. I think the recent fight you saw between Apple and the FBI on this iPhone, the unlocking of the iPhone, was a sign of how far this debate has come in our direction. I think the pendulum has begun to swing back, that there is increasingly business leaders and the public understand the need of not giving the government unfettered access to our personal communications. I actually think it's one of the places where, as my generation and those above me age, the younger generation understands this somewhat more almost intuitively. That the way we interact with the world is very much through these devices. They are not neutral in that way. They are extensions of ourselves. I often talk, when I talk to some of my older, Anthony, why do you care? If you have done nothing wrong, why do you care if the government has all your data? I care because I'm not sure the government hasn't done anything wrong yet. You'll forgive me for being a bit skeptical. And then we remember our history with J. Edgar Hoover and others about the compilation of surveillance files that can be used to squelch dissent explicitly. I also know that if I believe that the government might be intercepting my communications, I might self-censor. And so if I begin to say, well, I'm not sure I want to say it exactly that way, because I worry that it might end up in a government trove, then we as a culture change, and then we as civil society suffer. We begin to adapt to the worry that there might be this pervasive surveillance over our shoulder. When people say, I have nothing to hide, so what do I care if I collect my personal data? It's almost as if someone said, I don't need the freedom of speech because I have nothing to say. Someday you might have something to say, so you want your freedom of speech. And someday you might have something you want to hide. And you don't want it in the government's hands. And so you want to stand up for our privacy rights now before it's taken away. I actually think this one is one where we are making progress and we might win. I'm incredibly hopeful. I also try to describe it for some of my counterparts who may be a little bit older and just say, I don't understand why everyone's so obsessed over the smartphones and how is it different, and it's just a tool. And I always say, if you go to Starbucks and you leave a pen on your table, and you go to the bathroom, or you go to get another double latte, and you come back, and your neighbor has picked up the pen to write a note, and they say, I'm sorry, I just need to borrow your pen. You're like, okay, that's no problem, right? You leave your iPhone on the same counter, and you walk away to get your double latte, and someone picks up your iPhone and starts using it to Google something, and then you come back and you're like, what the hell are you doing, right? There's something innately different about what those devices connect to us. They're not just a tool. People feel them as extensions of themselves, and so we have to give that, I think, the primacy of protection, because they are extensions of our minds, of our spirits, of our thoughts, of our secrets, of our desires. And that's why I think it's critically important. So those are the three I think we're making progress. The three where we're fighting mightily: abortion rights. If you haven't figured that out, then welcome Rip Van Winkle. You know, this is still, I think, probably been one of the most challenging moments for abortion rights, and it's been challenging almost since the moment that Roe versus Wade was decided in 1973. But these last several years especially have been important and challenging. And it's not our opponents who fundamentally want to remove a woman's right to choice have been doing so bit by bit, chipping away bit by bit. It's not the wholesale assault and trying to overturn Roe versus Wade, but it's by requiring a waiting period here, by making the parental consent law more cumbersome there, by introducing requirements about the fetal pain possibilities of terminating a pregnancy. Little by little, they try to limit the context in which a woman can exercise the right to terminate a pregnancy. And increasingly, you find the case that's before the U.S. Supreme Court this term, the one out of Texas, is another veiled attempt to protect women's health. They say, we have enacted these new restrictions because we wish to make the abortion clinics more protective of women's health. And so we want to require doctors to have admitting privileges in local hospitals in case something goes wrong. We want the local abortion clinics to have the equivalent level of care as ambulatory clinics, all for the women's good. In fact, what they're doing is creating such a high bar for both doctors and the clinics that the clinics have begun to shut down, making it much harder to operate in some very difficult places. And so what you're finding is the squeezing of both the service providers and the chipping away at rights, which we find increasingly problematic. We have been fighting mightily. It's probably our most active DACA at the moment, especially because all of this has to be most often fought off state by state. And I think ultimately there will come a moment when it will be the Alamo, when either we will get this country to recommit to a woman's right to choice, period, or we'll begin to descend into a very difficult moment. Some of your presidential candidates suggest that we should go down the difficult moment, that not only should abortions become unlawful, but women who exercise their right to terminate pregnancy should be punished. That was a statement from Mr. Trump about 10 days ago that he can walk back because it was just so far out of step with even his own party. It's kind of fun to watch, you know, when Ted Cruz is lecturing Donald Trump on abortion rights. It's kind of like you've got to say, you can't make this up. This is better than any kind of entertainment program you can find on television. But really, the canaries in the coal mine, they're singing, and we have reason to be worried about them not being so vocal if we continue down this path. So abortion rights is one of the ones I think is most essential. And lifting the scarlet letter A from abortion. When you look at the numbers, you see that allegedly 1/3 of women have accessed the services that have terminated a pregnancy. And there is such a stigma attached to people who have terminated a pregnancy. That stigma is what is making this challenge harder and harder. The stigma behind being gay is what precluded our ability from getting LGBT rights. And it was only after we were able to say, we're not going to wear the stigma, we're not going to hang our head in shame, we're not going to pretend we're lesser than because we love a person of the same sex. It's the same challenge, I think, in the public psyche that's got to be brought in the abortion context, and to lifting the scarlet letter A from abortion, and that a woman has a right to keep or terminate a pregnancy as she chooses, and the decision between her, her family, her doctor, her God, she has one, but not for a politician to be that equation. So that, for me, is a key issue. The two other really tough ones, immigration. Obviously, when elections are hard for immigrants' rights because they're kind of the go-to scapegoat. So you see that with Donald Trump and Ted Cruz. There's an interesting debate between Bernie Sanders and Hillary Clinton about who's pro-immigrant enough and whether he was not sufficiently Bernie Sanders was not pro-immigrant. It becomes a live issue for every election. And that has a ripple effect as you move down the states. We had to sue the states of Texas and Indiana when the governments in those states tried to block the resettlement of Syrian refugees after the San Bernardino terrorist attacks. They tried to pull funding for settlement for refugee resettlement agencies and say, no, we don't want any Syrians in our backyard. And we jumped in and sued on behalf of some local nonprofits that said that that was not within the proper purview of the state government, that those decisions are properly delegated to the federal government in terms of immigration policy, refugee policy. Final issue, voting rights, the right to cast a vote, a vote that's meaningful and counted. Here, what we're up against is often kind of efforts by some governors and state legislators to pass laws that make it harder to register and to cast a vote. Things like photo ID requirements or proof of citizenship, proof of residency, making it even harder for people to register and to cast a vote. There are other issues that are also problematic in terms of voting, but those are probably the most onerous. And it sounds, again, very, very logical. They say, we want to make sure that we contend with fraud at the polls, so we want to make sure that if you're going to go vote, show me your state-issued driver's license, right? Sounds wonderfully logical, but you got to peel it back. First, how much fraud is there really in voting, right? I know with the undocumented immigrants that are around me that I know that the last thing they're going to try to do if they're here illegally, without documents, is to run down to cast a vote on an election. They're working very hard to remain below the radar screen. Until you show me empirical evidence that there are many people who are not eligible to vote, trying to exercise the right to vote, I don't really buy the fact that there is this great fraud that needs to be prevented by these photo ID requirements. So then, photo ID. Sounds logical enough. Just go down and get a photo ID. Go to a local motor vehicle. Problem is that for a lot of folks, you can't. Our client in one of our cases is a 90-year-old woman who was born in the American Deep South, Mississippi. She was born, and when she was born, her family decided not to register her at the county clerk's office because the head of the county clerk's office was a local member, was the head of the local KKK. So they say, why are we possibly going to go and register our new child with a man who would burn the crosses on our front lawn? So they registered her in family tradition on the inside cover of her family Bible. Showed what her name was, her date, I think even her weight. She voted in every single election until they passed a new law and requiring photo ID. The problem is that she can't get a photo ID. She doesn't have a birth certificate. She's never been out of the country, but there's no way for her to prove herself as an American citizen. Without a birth certificate, she can't get a photo ID. She can't cast a vote. And increasingly, when you look at the numbers for the elderly, for people with disabilities, Also for young people, a valid state-issued license is not so easy for a lot of young people who are much more mobile in the early parts of their lives. Ironic that some of the laws in which they will say that a state-issued university ID card won't be allowed in places like North Carolina. But a government-issued right-to-carry card, right-to-carry firearms, will be allowed. It's just, we really are splicing these differences in ways that make it very clear that they're just trying to impede certain type of voters who vote a certain way from casting a vote. And that has been a big battle for us, especially in this cycle. We have a number of lawsuits in Wisconsin, in Kansas, Florida, in Ohio, that often deal with voter courage issues. And often states where the difference of how many votes turn out or are counted can make all the difference in terms of the Electoral College and can make a difference in the trajectory of national elections. And those are often the real hot button states. Those are our top issues. I'll say a bit about the Supreme Court and then I'll be quiet. The Supreme Court, for more than 20, for almost 30 years, those of us who've been working around the Supreme Court have always tried to be very measured in how we bring certain cases to the Supreme Court. There was even a big debate about whether the Supreme Court was ready for the same-sex marriage challenge that was brought. Try to be thoughtful, cautious. You're always looking to, with the eye of trying to convince Justice Kennedy, who is that swing vote, the most powerful man on the court, one vote that can make or break a case. So for decades, you've tried to keep cases that you're not sure of away from the court. You've tried to narrow the questions before the court. You've been playing a little bit of offense in kind of a hunkered down mentality. Now with the prospect of someday, of a fifth justice who might not look or vote like Antonin Scalia, right? A more progressive voice, which is almost anybody's likely to be more progressive than Antonin Scalia, may he rest in peace. Also with the possibility of having a fifth Supreme Court justice who might be more progressive, might be more thoughtful, might be more forward-thinking. You have to rethink everything you've thought about the court for the last 30 years. You have to go through every single one of the dockets that we've been through where we've lost 5-4, and you can say, maybe now we can revisit this. 5-4 on campaign finance, 5-4 on affirmative action, 5-4 on some of the abortion rights cases, 5-4 on some of the employment discrimination cases. You really are talking, if this were to occur, that you have either Merrick Garland or someone else, maybe even further more progressive than Merrick Garland, occupy that fifth seat, you can fundamentally rethink how you operate with the U.S. Supreme Court. Now, I know I get excited because I'm a little wonky. I'm looking at the students somewhere in the back of the room. But it can be incredibly exciting because you can think expansively about a jurisprudence that for the last 30 years we have thought more in a much more controlled, defensive posture. You can begin to think about what new challenges could be brought. In the LGBT context, for instance, we've never tried to argue the right to non-discrimination in employment or housing as being covered by federal civil rights statutes. There are arguments to be made. It is a bit of a reach. We thought it was too much of a reach the way the court was currently constituted. With a new, different composition of the court, you can make those arguments. And you could just begin this possibly new period for kind of a vote, kind of a jurisprudence that could be a renaissance for progressive politics and for liberties and rights. I think it's possible. I'm not promising it, but I think it's very possible. So that's where I remain optimistic. I thought I would close with that. At the end of the day, I have to remain optimistic. I can't do my job unless I remain optimistic. It's just the tales of woe that just get you down. But somehow, I go to sleep tired, but I wake up optimistic and energetic, and I'd be glad to take your comments and questions. I hope you join me tonight for a different discussion on criminal justice reform. But please, why don't you tell me who you are and what's your question?
Oh, my name's Matt, and I'm graduating with a BA in Poli-Sci, and hopefully going on to history grad school. So when Garland gets borked, what do you foresee for that?
Yeah, I don't think Garland's going to get borked. I think Garland is going to be ignored.
Do you think he'll slip through?
No, I think they're just going to let him sit.
Let him sit where?
Sit on the sidelines, and they won't act. I don't think the Senate Judiciary Committee, we've encouraged them to review his record and to consider his credentials. There is, as we read it, no, and there are some of our colleagues who think otherwise, but we tend to be strong advocates where we don't like to budge from outside what we think the true basis of the law. We don't think there's any constitutional requirement that Congress, that the Senate conduct confirmation hearings. Right?
So,
and so the way I see it play out is that he stays there, they squabble over this issue. Maybe some Republicans make noises so that they can kind of undercut the backlash. Don't be fooled when they talk about some senators meeting with Merrick Garland. That's a pure PR fabricated efforts to make them look a little kinder, softer, gentler. They had no intention of voting on his record. Then, if Hillary Clinton wins, I think he would probably withdraw his candidacy, possibly. I think that's what the protocol would be, to allow the new president the clean slate by which to appoint her own nominee. I think it would be much harder for even a Republican-controlled Senate to block her nomination, because it's in the first part of her term. Probably the first thing she does as president is announce who her nominee is. And I think ultimately the problem with blocking it for a full 4 years of her presidency would just be too great for the Republican Party to withstand. Obviously, if Donald Trump or Ted Cruz wins the presidency, then we're back to bunker mentality and keep things away from the court, because their nominee is not likely to be a friend, although not always certain. Remember, Justice Souter was a Bush appointee. He was a very good friend of civil liberties and civil rights, but I think more likely than not, if the presidential election will very much determine the composition of this court for the next 10 or 15 years. I feel pretty confident saying that. Getting borked. I think ever since Bork, folks have become folks who are making these decisions or advising the White House have become much safer in terms of not having a judicial nominee with a record that would allow them to get borked, if you use that verb. It's interesting. Merrick Garland, we've done a report on him. It's on our website if you care to read it. Not great on national security issues. Often more deferential to the law enforcement and prosecutors than he is to criminal defendants. But virtually no history on LGBT rights or abortion rights or immigrants' rights. It's rather remarkable. A man has been on the bench for as long as he's been. His record is so thin on the hot button social issues. Has a little bit to do with the fact that he served in the circuit for the District of Columbia. So a lot of what he sees end up being more administrative law cases and a lot of cases that have to do with federal jurisdiction, and so they don't have a lot of the same types of cases that have come up through the trial courts that you would see in most federal district or circuit courts. But it's interesting that they've picked a nominee who has almost no record on the issues that are most challenging to the right wing. So I think everyone's being very careful not to ever have a Bork situation. Robert Bork was unique in the fact that not only of his extreme views, but the fact that he was so open about them. And I think that also, that's not necessarily a good thing, that we know less about some of our justices of the courts than we'd like. Justice Ginsburg, who was the founder of the Women's Rights Project at the ACLU and general counsel at the ACLU and a dear friend of the organization, and we'll see her Monday, says openly that she thinks that if she would nominate this, she probably would never get confirmed. There's something wrong about a system that's evolved to such a place where a top jurist like Justice Ginsburg today would probably be blocked and borked because of her relationship with us. So I'm not saying that the system is working the way it should. You have another follow-up question? Please, why don't you tell me who you are?
My name is Linda Greiner. I work for the Mansfield Foundation. I don't know if this is in your jurisdiction or not, but Guantanamo.
Yeah.
It's such an anomaly. I mean, these people are being kept without trial, without representation. What, have you done anything?
Yeah, we have this.
Can you repeat the question?
Guantanamo. She says Guantanamo is such a tragedy in terms of people being kept without trial, languishing, and she asked whether it was in our jurisdiction and whether we've done anything. So we've done a great deal. I mean, often the hard thing with the ACLU is that we have too much to talk about it, so I have to pick 6, which still seems like twice too many, right? You're always supposed to do the magic 3. So Guantanamo, we are very actively involved in the representation of the high-value detainees at Guantanamo. So we have 2 full-time lawyers on our payroll who are the lawyers to Khalid Sheikh Mohammed. He is allegedly the mastermind of the 9/11 attacks. He is the one top guy, right? Who's being charged in military commissions. We jumped to his defense not because obviously if he did plan the attacks, we don't agree with him. We may not even like him very much. We don't have to like our clients. That's part of what we do. We defend sometimes very unpopular people when we think their rights and liberties are at stake. In this particular case, he's being tried in a military commission process, which is a court of first impression. It's never been used before. It's a mess. I've been to Guantanamo maybe 6, 8, 9 times. I've watched these military commissions proceed. They look like a court, they smell like a court, but they are not courts, right? People are just totally perplexed about how to work in this legal. They've never been used. They've been created for these cases, and they're falling apart, right? There are close to 250 pending procedural motions, right, that haven't even been adjudicated. Then we haven't even gone to the substantive motions, and then we haven't gone to trial, and then from trial, you have to go up on appeal, because these guys are being charged with the murder of 3,000 American citizens, and they're seeking the death penalty. So the reason why we jumped in is because we believe the system is inadequate and unfair. That needs to be scrapped. We need to use the federal criminal court system to try them. We jumped in because these are also individuals who have been tortured by policy of the U.S. government, by the highest levels of the U.S. government, were waterboarded. In his particular case, 183 times. So that seems to be a mitigating factor in terms of how you prosecute someone and whether you put them to death. And then third is because we don't believe the death penalty for anyone. And we kind of think that if we can stop the U.S. government from executing Khalid Sheikh Mohammed, it's going to be really hard to keep the death penalty alive for anybody in America, right? Which is our goal. Because if you can't execute him, you can't execute anybody, right? And so then we put the death knell to the death penalty. If you forgive the metaphor. So it is a complete and utter mess. And the only thing I will say, and then what they do say is that there is a segment, so those are the 5 that are the most prominent criminal defendants. There are another 40 to 60 individuals, they say that they can't charge, but they can't release because they're too dangerous, right? And we don't believe that you can keep people because you think they're dangerous. You either have to charge and prosecute them and convict them, or you release them. And it's not appropriate to have a form of preventative detention at Guantanamo. I think it's fair to say that everyone realizes that everything's come off the airplane. You know, nothing's working. I had a meeting at the White House just a couple weeks ago where there was, when I said, this is not working, this will never work, this is imploding, they nodded their heads. They know that the system is not working. And yet, I think very often our political leaders don't have the courage to kind of deal with whatever criticisms might come from the right and prosecute. I'm not saying they should be released. I want to be very clear. I'm saying that they should be prosecuted in established federal criminal courts with proper rules of procedure, with proper death-qualified defense attorneys, with a proper appellate process that's been used over and over and over again, rather than this every time is a case of first impression. It's a really bizarre situation at Guantanamo. You're in a courtroom. There's a glass wall from the gallery to the lawyers are behind the glass, and those of us who are observing are in the other half of the glass. There is literally a red light that looks like a little bit like a fire alarm. And when someone in the courtroom, either lawyer or one of the defendants, might be saying something that they don't want the observers like me or the journalists who are next to me to hear it, some U.S. government official has the ability to hit the button where the light goes flashing and then the sound is cut to the gallery, right? Some clerk, right, has the ability to say, oh, no, this is getting too dicey, edit it. Our lawyers have had to deal with it. Some of this you can't make it up because it's just too extreme. Our lawyers who are representing these individuals later on found out, because there are people at Guantanamo who are also agree with us, and so we find things out that we're not supposed to. So we found out, for instance, that the smoke detectors in the conference rooms that were set up for attorney-client conversations were wired with listening devices, right? And you're like, how can you have an attorney-client conversation that's confidential if you put listening devices in the smoke detectors in the conference rooms? And the government, after not commenting, said, even if they are in the smoke detectors, we're not recording it. And if we were recording it, we wouldn't provide the recordings to the prosecution. And you kind of say, what? We're talking, what court is this? You say, in God we trust, but who am I trusting here? This is kind of crazy. This is really kind of crazy. And it's one of those things that ultimately I think we'll walk away from this disaster, and we will charge these defendants in federal criminal court. I think they would move along much more expeditiously because you're not fighting over what the rules mean. So we'll see. I still remain hopeful. How about other questions? Well, we have a bunch, so we'll take 4. 1, 2, 3, and 4. Tell me who you are and what's your question.
Mike Chess is retired botanist, and I want to bring up the subject of Second Amendment. It seems to, and of course, we live in the Second Amendment country.
Territory. I do.
And it seems like it's being widely misused, misinterpreted to promote the overwhelming farming of all populations beyond any comparison to the rest of the world. And I assume that life is a civil liberty.
It is.
And I think that this has resulted in the loss of liberty for an awful lot of people because of that misinterpretation.
Yeah.
I wonder if you would comment.
Yeah. The ACLU has just recently reviewed its policy on the Second Amendment. I often would get teased with my friends, and actually I do have a couple of friends on the far right who would say, you know, you say you're for the Bill of Rights, but you go from the first, and then you skip the second, you go to the fourth, you go to the fifth, you go to the 13th and 14th, and the only one you don't believe in is the second. I said, well, I believe in the Second Amendment. I also believe that there are very important forces who only focus on the Second Amendment, right? So the NRA and the Bloomberg and every town, they only have one amendment. I'll cover the other ones. So the truth is we don't do a lot on the Second Amendment. Our position is one that I'm glad to articulate for you. There's not much litigation or advocacy we can do. We believe that the right to bear arms, whether it's an individual or collective right, it's kind of not the point anymore, especially in the aftermath of the Supreme Court case, Heller versus Berman. It's just, we can have a good kind of law school debate, but the fact is that the Supreme Court decided that it is an individual right to bear arms. But that individual right to bear arms can be regulated by the government, and it's not unfettered by government regulation. And so government has the complete authority, ability, responsibility, we believe, to regulate firearms that are especially dangerous to public health. You know, the assault weapons ban is a no-brainer. There's proper screening for people who want to buy firearms. The closing of the loophole, the gun show loophole, where the same requirements are not adhered to in a gun show. All of that, we very much believe, fully within the right of the government to enact, fully necessary. At the end of the day, that's a position that we have, like on many other issues, we have positions that we believe prostitution should be legal, that it's a victimless crime. But we don't do a lot to make prostitution legal, right? It's just Las Vegas and a couple of other places that have it. And so we have a position on the individual right to bear arms that can be regulated by government, but there isn't much more for us to do. And sometimes I get criticism saying, Anthony, with this kind of epidemic of gun violence, anything you can do would be incredibly helpful. I'm not so sure. I mean, I think part of the challenge for an organization like ours is broad, and we have to really pick our places where we think we can really make a difference. And just because something is an important issue doesn't mean that we need to spend limited staff and time, resources in doing something if we don't know where we can move forward. So I think you probably agree with our position, but you're probably frustrated that we don't do more about it. So is what I'm guessing. Please.
I noticed out of the 6 items you mentioned, Laura, on the face page, it mentions free speech though. And I'm particularly concerned with the issue of free speech on campus, which seems to me to be highly important. March 4th issue in the Atlantic, which is about a mainstream magazine, as you think a mainstream liberal, there's an article, the glaring evidence that free speech is threatened on campus.
Yeah.
You could probably talk for about an hour, but what's your thought on that? And since you went to Woodrow Wilson, I think Woodrow Wilson's name should be taken, but that's a side issue. That's a side issue.
Yeah.
But the issue of one of the Atlantic articles, it quoted a California professor who wisely chose to be anonymous, said, I'm a liberal professor and I'm scared to death of my liberal students.
Yeah. Well, look, I think some of what's going down in college campuses and universities, I've gotten myself in a little bit of trouble because I go to liberal colleges and campuses, but I don't have to stay there, so I can say things that are provocative. So I was at Berkeley about 3 months ago, and I got this question. And I got a question from a student who obviously wanted me to kind of talk about the need to protect the school environment from being a hostile place, which is fundamentally a necessary responsibility. I mean, universities do have an affirmative obligation to make sure that the educational environments do not become hostile and therefore impede the ability for all students to learn. That being said, that's a pretty high bar for me, right? It deals with sexual harassment, it deals with incitement. A lot of the stuff that some of these universities are now dealing with, these microaggression alerts, I find ridiculous, right?
Can I just interrupt for a second? I'm very happy that I reached the age of 70 with not ever having heard the word microaggressions.
I mean,
And shortly after I heard that, I was watching the Totally Deal there.
and I tell these young people, I said, how can you know, it's different for high school students. Right? High school students are more impressionable. They're minors. We need to protect their ability to kind of figure out right from wrong, and you know, they get confused, and you know, there are things that are inappropriate in a high school context that are totally appropriate in a college context. And the idea that you have to give these microaggression alerts if you're going to teach some of the classics because they might deal with kind of instances of rape or murder, I find it, you know, I find it astonishing. How could you? You mean you want an alert in kind of the Greek tragedies classes when we're going to talk about Electra, or we're going to talk about some of these kind of very difficult family dynamics among the ancient Greeks, and you want to be able to opt out of these classes? I find it very peculiar. And I think, that being said, I think that there is, in some instances, there are places where the climate is hostile to women and to especially students of color, and that for many years there's been not the level of attention from the administration or the faculty on these issues. And so I think some of this is coming back to haunt us because we have been a little bit playing a blind eye to some of these issues. I was astonished, for instance, it was a New York Times article that Harvard hired its first Title IX compliance officer. First one, just this last year. I mean, that's kind of crazy, right? The Harvard University, with endless amounts of money that they mint off of their alumni, never had a full-time Title IX compliance officer that could really kind of provide the guidance to the faculty and the administration. I think, you know, obviously something more needs to be done there. So I'm not saying that not everything is perfect. I think there are things that the schools need to do, but I think we have to be very careful not to create an environment where colleges and universities begin to squelch the ability for students to engage each other, and the faculty to speak their minds, and the faculties to engage each other. I remember the debates I had very deeply with my best friends. Right? I had one man who was my best friend to this day. I'm the godfather of his two children, a Sikh man from Calcutta, and my other best friend, a Bangladesh woman who was Muslim. And I remember having it out with them over what their religion's views were of women and gays and the castes and the untouchables, and I was very politically incorrect, right? Where I was just like, I don't get this caste system, you know? I don't get these untouchables, I don't care where it comes from, I don't care how it's ridiculous. Speaking my mind as I would over too many beers as a college student in a dorm, and that would spill over sometimes in the classrooms. That's what colleges are about. Colleges are about the give and take of ideas, about testing your I was wrong on a bunch of things. I learned a lot. I learned to have a greater respect for the Hindu religion and for the Muslim faith, and to find that there's pluralism even within those faiths, and that my ignorance was more kind of American kind of naivete than anything else. But I think if we don't allow colleges to play that role in young people's lives, colleges are going to fail. And I do worry that there is this growing push. A lot of the work we do in terms of what speech on college campuses is handled by our local offices, so it doesn't necessarily rise up to the national office headquarters, because it means that there's something wrong with the University of Oklahoma. Our Oklahoma office will handle it. And if something's wrong with the University of North Carolina, our North Carolina office will handle it. And not to say that there isn't more we can do. I agree with you that I think that this is probably one of those moments, a little bit like the speech codes we saw in the 1980s, or these free speech codes that some of the liberal universities enacted. I think the principles promulgated by University of Chicago, I think they're called the free speech principles. If you Google University of Chicago free speech principles, Jeff Stone is one of the authors of it. I think that's the best roadmap for how colleges and universities need to deal with these issues. So it's not to say that we don't work on it, it's just, most of what we do on the First Amendment is enforcement and compliance, which is to basically make sure that the current law, the way we understand it, is applied in real context. It's not like in the context of criminal law reform where you're actually trying to do law reform, right? So that's why I often skate over the kind of compliance work that is very much our still bread and butter.
Thank you.
Please, Anthony.
Thanks so much for coming, and thanks so much
Did I
for
get your
your
name right?
continued support of our amazing ACLU team in Montana. I had the privilege of working with them very early on in my career. It's remarkable. Montana's very lucky, and part of it's because of the national support. On this compliance thing, so I noticed maybe you slipped and you mentioned campaign finance as one of the areas where you're hopeful with the change. The ACLU was on the winning side of Buckley versus Vallejo. It was on the winning side of Citizens United. It was on the winning side of the campaign contribution limit challenge that Montana's facing right now.
And
So
then we
where
change
do
our
you-
position after.
So talk more about that.
So there's a little bit of insider baseball. So there's probably no issue that has been more hotly contested and more vigorously debated, often to like the Montagues and the Capulets of Verona, than campaign finance. I think it's been debated at our national board 13 times. And each debate is usually a 10-hour, it's multiple meetings where the debate continues. So we're talking the most amount of time spent on this issue because there are real issues at stake. There's the issue of freedom of speech, and freedom of speech in a political context when it matters most, like in an election cycle, and the integrity of the election system, and whether or not the election system is becoming corrupt because of the pervasive and problematic role that money plays in politics. And so when you have those two kind of clashes of values, that's where it makes life very difficult for figuring out a position forward. Historically, the ACLU has always been on the side that to err, if you will, more speech in the middle of an election is the best thing for a democracy. So that's where our longstanding kind of skepticism on campaign finance rules, that we think that that's political speech, that you want to be more careful than not, that you protect that during times of elections. And in the Citizens United case, we actually filed a brief that was on the winning side, but that the Supreme Court went further than our brief suggested. We thought that the ban on you remember this, the Hillary Clinton movie, that was an attack on her, whether or not it should be counted as a campaign expenditure. And we thought that the court could have struck down the ban in a much more narrow, as applied way than it did in the Citizens United case. The Citizens United case kind of blew open the door to the barn and blew off the roof to the barn and blew off the doors to the barn and kind of went there in a kind of a much more aggressive way. In the aftermath, so we agreed with the outcome of the Supreme Court case. We didn't agree with the ruling. We didn't agree with the thinking or the decision that led to that case. Because of that Citizens United kind of overreach, right, which I think is one of the primary cases of showing kind of judicial activism from the far right of the court, right, where they answered a question they were asked and then they went even further. Because of that ruling, we had another round of debate, and people were then at that point so flummoxed over the kind of Citizens United case that for the first time in 40 years, my board, which is the one that decides the overall policies on these issues, decided that we would be willing to accept reasonable limits on both campaign contributions and expenditures. Right? It's the first time we've crossed that Rubicon. So that's where we are, right? We're now back more in the camp of the campaign finance reformers, but it's like showing up late to the party. The party's already kind of done, right? Because the party was decided with Citizens United. Now, I think with going forward, we've never been fans of the idea of a constitutional amendment process, which I think is crazy. The idea that you'd actually try to ask this this Congress to reconsider rewriting the First Amendment will walk away with nothing, right? So I've never been fans of kind of the idea of states with their kind of consideration of an amendment to Citizens United and then walking out to Congress. I think ultimately with the change in the Court 5-4, to kind of curtail the excess of the broad decision of Citizens United is certainly, I think, a possibility. It's one of the things that people are beginning to talk about and think through. It might be that that's one of the things that you can do now that Antonin Scalia is not the fifth vote on the court. I do think there's a problem with money, the problem with money politics. My solution has always been public financing. And the idea of regulating political speech, just like we regulate 501c3 or 501c4 speech, tax that speech which is political, 501c4. Use that, I think you could devise a scheme, which in this context would be hard to push through Congress, but devise a scheme where you tax political speech and then use it to fund a campaign finance, a public financing system. Could be kind of a very interesting idea. The possibility of getting that done in this Congress are probably not too great. The possibility of piloting some of this at the state level, I think, is much more exciting. It's one of those issues that continues to kind of to change, both around us and we around it. So we'll see what we do on any litigation on campaign finance. So I have your question. What is your name?
My name is Casey Charles. I'm in the English department. And first of all, I want to thank you for being here and let you know that we were quite happy in the late 90s when the ACLU came to our rescue to get domestic partnership health benefits. And you supported us on that case, part thanks to Scott.
Yeah, that's right. I was
It's
trying to
really,
contact Scott. Yeah.
we're really happy about that. And I wanted to follow that up with a question about trans rights.
Yeah.
And what the ACLU might be doing in relationship to the Not In My Bathroom about commerce and how you guys are approaching that.
Yeah. And you know, I was trying to keep my talk somewhat, so I skipped over, when I talked about we were winning on LGBT rights and we're fighting the headwinds on religious refusals. The second thing we're fighting on LGBT rights is the backlash on trans rights and using trans rights, the rights of transgender individuals, almost as an excuse to not confer anti-discrimination protections to LGBT individuals, or to even derail and kind of a broader equality agenda. I mean, we were very actively involved in the kind of the local referendum in Houston, the first of the kind of the transgender bathroom referenda, where the opponents, it was again a non-discrimination law that was already in place that we were trying to retain, that our opponents ran these ads that tried to depict the word that this law were kept in force, that transgender individuals would wander into the girls' bathrooms and put young women or girls at risk. I think, again, we need to do a lot more. We need to fight them tooth and nail, right? Because we don't get to carve out protections, especially on groups that are increasingly clear that are the subject of public animus, right? It's hard to now say there's no problem with the trans community, because clearly people are much more outspoken in their kind of their prejudice and their animus. And so, in some ways, the backlash against the transgender bathroom issue makes the point that discrimination is alive and well, and therefore we need non-discrimination laws. So it's almost like their frenzy feeds our case, right? At the same time, we need to kind of find a way to change public, attitudes, which I think we haven't done a very good job of yet. In the LGBT context, we won marriage equality when we stopped talking about sex and started talking about love. Right? When we pivoted from talking about homosexual lifestyle, or homosexual orientation, or homosexual behavior, and we started talking about committed, loving long-standing, enduring partnerships, we won, right? We humanized something that people had a hard time wrapping their minds around. I think in the trans context, we need to come up with something very similar. We need to kind of, and I think slowly that will come. I think that there's a very vibrant transgender community that's becoming increasingly outspoken, increasingly visible. But I do think that it's going to require a little bit more work and a lot more conscious effort. I don't think we can afford to just say, we'll take 50 cents on the dollar and we'll get rights for the LGBT people, and then we'll forget the T for now and come back to it later. I think we have to use this momentum we now have to get the rights for everyone, because they are indivisible, as we've all been told. Anyway, thank you very much.
Thank you very much.